you can, you won't, and you don't stop. Or when you can, you won't, and you don't stop. Mike D coming down for sure.
So we've talked about the legislature, but what about the executive? Do they ever make any law? What's their role in law? Okay, so theoretically, the governor or the Governor-General in the Commonwealth area runs the government. They're the head of the executive arm. However, what happens in reality? In reality, let's take at the Commonwealth level, the Governor-General acts on the advice of the Federal Executive Council, which are the ministers, right? And we know that the ministers are elected representatives in Australia, okay? So by convention, the Governor-General always does what the Prime Minister recommends, with some very, very rare exceptions, which I don't think we need to worry about for our subject. So what really happens? A political party gets elected to power. What does that mean? They have a majority of seats in the lower house, the House of Representatives in the Commonwealth. And they get to choose who's going to be in charge of the various aspects of government. So they appoint ministers, okay? They give them portfolios. Federally, say Defence and Treasury. These are called senior ministers. There are less important portfolios or areas of government where we might have junior ministers. A minister can come from either House of Parliament. If you're a member of the major political party but aren't a minister, you're called a backbencher because you sit on the back benches of Parliament. The front benches are where the ministers sit. Practically, or on a day-to-day basis, this power is exercised by a smaller group, a subset of all the ministers called cabinet. And you'll run across that in the press all the time. The political party who didn't have the largest number, so they're the second biggest, they got the second biggest vote, are called the opposition. The leader of the opposition often mimics having their own ministers and a shadow cabinet. But can that executive actually make law? Okay, so Parliament will often do a two-stage process. First, it will pass a law which sets out some principles and objectives of regulation. Then they'll delegate the detail rules to the executive. So it might delegate rulemaking to government departments or local governments. What you will see is that these laws, delegated legislation, are called things like regulations, bylaws, local laws, or orders in council. They have the same effect as an Act of Parliament. So they do have the power of being a law. But remember, they're accountable back to Parliament. So if you've ever wondered, how is it at QUT they can fine me for parking somewhere, but I can't fine someone for parking on my front lawn? I don't have the power to fine someone for parking on my front lawn, but QUT does. Why? Delegated legislation. Parliament has delegated the right for QUT to make that law. Okay, so there's a big difference there, and that's the way that delegated legislation works. Now, delegated legislation can be a bit controversial. I mean, there are obvious reasons why you would do it, right? It would save time. It would give experts the ability to write this detail below it. However, it's a fundamental problem, right? Because now you have unelected people making law. Not only that, you allow people to make rules, they're going to make rules. So it'll get a proliferation of rules and laws as a result. So there's this balance in the advantages and disadvantages of delegated legislation. A really great example, if you're looking to understand how they operate and why you would do it, is provided by the Tobacco Plain Packaging Act. What you can see is the difference between the principles and what the Act was trying to do and the actual level of detail that you need to go into if you're going to try and achieve those principles. Parliament would gum up trying to make this level of detail. Okay, so it concentrates at this level, delegating detail where necessary down into those experts who understand how it works. Okay, so we've got the legislature making power. We see that the executive can sometimes make it if Parliament gives them the power. But how is it in a liberal democracy that judges can make law? Well, that operates through the doctrine of precedent and also their role in applying the law and interpreting the statutes that the legislature might come up with. Let's have a bit of a look at that. So, wherever we have decisions being recorded and published, which is most of the time, we get case law. The doctrine of precedent says, in cases of similar facts, a court must, right, that's what obliged means, a court must follow the earlier decisions, the earlier rationale of higher courts within the same hierarchy. Okay. Why is that important? Well, remember when we talked about good law? What does this do? This rule means we get certainty, right? If a high court has made a decision, the others are going to follow it. So there's certainty. And a bit of fairness in that, right? Because similar decisions are going to be made similarly. Since the cases are published, it also means that the law is accessible. So we can start to see that following the higher level decisions, the approaches in those higher level decisions, leads to very good outcomes in terms of having good law. While we have these good attributes coming about from following decisions that are actually made before, we also want some flexibility. This is where the hierarchy of the court becomes important. What we want is the best, most experienced judges who understand, probably better than most, how their decisions might impact on society. We want those judges to be able to maybe alter the law and adapt the law as necessary to give it the flexibility. But to provide the certainty for the system, we don't want the other judges to be able to do that. We want them to be able to follow the lead of those very experienced judges. That's kind of what the doctrine of precedent is trying to do. Get this balance between certainty, fairness, flexibility, and accessibility in some sort of balance. Okay, let's look at the doctrine of precedent then. So when a judge makes a decision, that decision about a question of law is called a precedent. If you're higher up in the hierarchy, so an intermediate or a superior court, they're the technical names, that just means you're higher in the court hierarchy, then you can establish binding precedents. So a binding precedent is a decision, right? A decision, the rationale behind a decision of a judge higher in your court hierarchy. So you only have to do it within the same court hierarchy for courts that are higher. If it's outside your hierarchy, then they're not binding. It might be what we call persuasive. Another important fact to understand is that within any judgment, there might be two kinds of things that a judge does. They give the reason for the decision, the ratio decidendi, and they also may make other remarks about what they would do if facing a certain situation. That's called obiter. Only the ratio is binding. Only the ratio from a higher court in the same court hierarchy. Put simply, courts must be in the same hierarchy. Higher courts bind lower courts. A single judge is not bound to follow the decision of a single judge in the same court, but is bound to follow a decision of the full court in the same court. And so what we have here is the court hierarchy systems that are in place in Australia. I'm going to go into more detail in this in the next module, but for now I just wanted to introduce it. Okay, so essentially we have a hierarchy within each state and then a hierarchy in the Commonwealth. That replicates the separation of powers that are put, not the doctrine of separation of powers, the split of powers, the power sharing that occurs via the Australian Constitution. Okay, and then within that power sharing, there are levels of courts. So in Queensland, we have a magistrates court, a district court, original and appellate jurisdiction, and a Supreme Court, original and appellate jurisdiction. Notice that if you're not happy with a decision in a certain court, so for instance, you're in the magistrate's court and you're not happy with the decision, well, then you can appeal to a higher court, which is what these blue arrows represent. Within Australia, what do we have? Well, we have the High Court, which is the top court in the country and unifies our system. Notice you can appeal from the top Supreme Court in a state, like in Queensland, to the High Court appellate jurisdiction. We also have an original jurisdiction in the High Court. It's mainly for constitutional issues, right? Because there's nowhere else really to go for those constitutional issues. So we'll come back to that. We then also have two court systems. There's a separate court system for the special area of family law, because it is such a specialised area, particularly involving kids. And then we have the federal court system, which handles all the other areas, areas like, say, intellectual property and competition law. This is how judges actually make law. I think we've already been through the idea of the doctrine of reception and terra nullius earlier. We looked at that. A more business-related example is the changing of the law by the reinterpretation of a term. So Section 51 of the Constitution says the Parliament shall have power to make laws with respect to foreign corporations and trading or financial corporations. What did that mean? That means if it's not a trading or financial corporation, if it's not a foreign trading or financial corporation, then the states have the power, right? So the question of what is a trading or financial corporation is very important, because if a corporation is a trading corporation, then the Commonwealth can make laws around it. Okay, if a company is not a trading corporation, the Commonwealth can't. Early on in 1908, the High Court, a justice in the High Court, essentially said a lot of companies are not trading corporations. Okay, so he said like a mining company is not a trading corporation, a manufacturing company is not a trading corporation because they're not trading things. However, that's changed. The current High Court interpretation of a trading corporation is anyone with trading activities. Okay, and you don't even need to be making a profit. So essentially, if you're selling things, you're a trading corporation, which is almost all corporations. So it's gone from very few corporations to most corporations. See that in the real world, there's this kind of interaction between what the courts are doing and what Parliament's doing. The courts have to interpret it, and in that interpretation, they can affect the level of power that a government has and how that power is actually exercised. And we're going to do that next week when we get into this issue of statutory interpretation. How do you interpret something like the word trading corporation? But we'll leave that to the next module.